Hello, I am Morley Nair. I am an immigration lawyer in practice for the past 25 years. During this period of time, my office has processed thousands of H-1B visas and hundreds of green cards, in addition to a large number of L1 visas, family-based visas, naturalizations, etc. The material in this video is for information purposes only and should not be taken as legal advice for your individual immigration situation. You must seek competent legal advice before proceeding with your individual immigration matter. The information in this video is of interest to you. Please like it and do not forget to subscribe my channel. I'll be coming with more useful videos like this in the future. In this video, we are going to discuss two important subjects in the field of employment-based immigration: the October 21 Visa Bulletin and the question whether or not to downgrade from EB2 to EB3. First, the Visa Bulletin. The October 2021 Visa Bulletin has good news and bad news. First, the bad news. The worldwide priority dates in the employment-based categories have not moved at all in the month of October. Also, there is a retrogression in EB3 India date for filing from March 1st, 2014 to January 8th, 2014. Thirdly, the Visa Bulletin predicts that EB3 India and China priority dates will retrogress as early as November 2021. Now to the good news. The good news is that EB2 date for filing for India has seen a big jump of 220 days from December 1st, 2011 to July 8th, 2012. Also, in addition to this, USCIS has said that date for filing will be allowed to file adjustment of status applications in the month of October 2021. This means that a large number of applicants will be able to file their adjustment of status applications for themselves and their dependents in the month of October 2021. Now to the question of downgrading from EB2 to EB3. The dates for filing retrogression in EB3 category for India and also the forward movement in EB2 date for filing for India. These two factors have made a decision difficult whether or not to downgrade. Now, to take a step back, in October 2020, when there was a huge jump in employment-based visa priority dates, the gap between the EB2 dates for filing and EB3 dates for filing was almost 3.5 years. EB2 dates for filing was May 15, 2011 for India, and EB3 date for filing was January 1st, 2015. And also the USCIS had permitted use of dates for filing to file adjustment of status applications. A large number of downgrades were filed in the month of October and November. This resulted in the retrogression of dates for filing for India from January 1st, 2015 to January 1st, 2014 in the month of December itself. Also, the USCIS stopped permitting the use of dates for filing and reverted back to the final action dates in the month of January 2021. It is a tough decision to make whether or not to downgrade from EB2 to EB3 solely based on these predictions. Predictions are just that, predictions. A case in point, in his August 2021 YouTube interview, that is last month's YouTube interview, Mr. Charlie Oppenheim, who is responsible for the administration of annual ViSA numerical limitations at the National ViSA Center, said that he did not foresee any retrogression in employment-based ViSA priority dates for the fiscal year 2022. But within a month of that statement, we have seen the EB3 date for filing has retrogressed for India from March 1st, 2014 to January 8th, 2014. Also, the ViSA Bulletin predicts that as early as next month, November, there can be retrogression in the EB3 numbers, EB3 priority dates for India and China. All would depend on how many adjustment of status applications the USCIS receives in the month of October 2021 as a result of this big jump in the date for filing that we have seen in the October 2021 ViSA Bulletin. Also, it remains to be seen how long USCIS will continue permitting the use of dates for filing to file adjustment of status applications. As I said before, we have already seen that in January of this year, USCIS reverted back to the use of final action dates for filing adjustment of status applications. In his video interview, Mr. Charlie Oppenheim also said that an adjustment of status case where an EB2 to EB3 downgrade also has been filed will stay under EB2 until the EB2 to EB3 downgrade is processed. So if the EB2 priority dates become current, that they become the final action dates before that, before the EB3 is processed, before the downgrade is processed, the case will get approved under EB2. Otherwise, it will go to EB3 processing. Now, this means that the applicant will have the best of both the worlds. I mean, there is no disadvantage to the applicant because he or she filed an EB2 to EB3 downgrade petition. Now, taking all the aforementioned factors into consideration, I think it is still prudent for potential EB2 applicants born in India who have EB2 priority dates closer to January 8th, 2014 to think about, actually to seriously consider downgrading their EB2 I-140 petitions to EB3. I mean, to have their employer file a downgrade petition from EB2 to EB3 and along with that file the adjustment of status applications for themselves and their dependents. Again, this is what is prudent in my judgment. There could be different opinions out there. That's all for now. In my next video, I will be discussing the budget reconciliation bill, which has far-reaching and really spectacular immigration-based recommendations, which is being seriously discussed now, and where the Senate parliamentarians' approval is awaited for further proceedings. Thank you for watching. See you next time.